The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Please be seated. We'll call the third case on this morning's docket, 106093, State of Kansas versus Lewis.
May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Tony Lewis. Justice Lukert, if you would please reserve 2 minutes rebuttal time.
2 minutes.
Thank you.
Thank you.
There are several issues raised in Mr. Lewis's brief, a lot, and I could talk about each one for about 20 minutes. But today I'd like to only focus on issue 1, the district court's response to the jury's question. But before I do that, I wanted to quickly address Mr. Lewis's 5 life sentences. We believe those should be vacated and remanded for resentencing. Under Trutloff, he committed this offense in 2009 before the before the statute was changed, and we were operating under 2 prior conviction events. Here, we don't have that. We only have 1 prior conviction event, the Geary County case. So we believe that his 5 life sentences therefore don't meet what would be an aggravated habitual offender. And also we have Turner, which came out, and I filed a supplemental brief on stating that the 2 rape sentences would fall under persistent sex offender. So now that I've addressed the 5 life sentences, which we believe should be remanded, I'd like to jump to the first issue. Now, there are 10 charges filed against Mr. Lewis. There are several victims. The jury goes back at 11:15. The jury retires to the jury room. And I apologize for going through the facts, but I think it's essential. 2 hours later, the jury asked the court, can we find the defendant guilty on all but 2 counts? The court says yes. 2:40 goes by, 2:40, so we have an hour and 25 minutes. The jury asks, if we're unanimous on all but 2 counts, are those 2 counts going to be thrown out, or what will happen to those? And then parentheses, we are not unanimous on 2 counts, only by 1 vote nay. The district court then receives input from the parties. Now, this is where we disagree, I and the state, about whether we have invited error here. The state, well, I think the answers probably would be the county attorney's decision. They could be retried, or if he felt it was not necessary to pursue, they could be dismissed, or it'd be up to the county attorney to make their decision. The defense gave a really simplified response of, I would just say something like, you should not concern yourself with this issue. Hearing those 2, the court makes a 180 and does something quite different, and does something more egregious than an Allen instruction. He tells this jury that is hung, I'm going to refer them to instruction number 3. Your duty is to determine if the defendant is guilty or not guilty. The disposition thereafter is a matter for determination by the court. What happens after that is quite telling. At 4:30, we don't have a jury that is hung on 2 counts. We have the jury doing its duty that the district court said it should do.
And counsel, where did the defense counsel object to what the trial court was about to do?
The defense counsel did not object. The defense counsel gave a different response.
That was prior to the court saying what it is they were going to do.
Correct.
What the court was going to do.
Right.
And then after that, the defense counsel says nothing.
Right. Now, the contemporaneous objection rule applies to evidence, not to jury question. And so I would argue that we are not procedurally defaulted by that rule. We do have a defense attorney giving a different response from the court. And as I cited under Jones, if you give a different response, this issue is preserved for review.
That's a Court of Appeals decision, if I remember right.
Yes, it is. It is a Court of Appeals decision. I had that app next to it, so that hurt me. Can this court consider this issue? The state's argument is that this is invited error. argues that the defense counsel invited this error because the court gave the same answer that defense counsel gave. Now, as many times as you could look at it, that's not the same answer. She was giving a very simplified answer. Don't concern yourself about it. The court told the jury they had to reach a verdict. Its duty was to reach a verdict. And I've cited Bruce and Kramer distinguishing those two cases that this was not invited error. Here, no matter how liberally construed, the jury was told of its duty, and there is evidence that the defendant acquiesced, as in, I have no objection, that's fine with me, Your Honor. We don't have that here. Now, why this is error seems quite clear. It is, first, it doesn't answer the jury's question. It tells them about a penalty that they shouldn't be concerned with. That's from Pick. It pulls up from Pick, and that's really relating to what the sentence should be. So we would argue that's a misstatement of law because the instruction is incorrect. More importantly, it's coercive because it's a forcing type instruction. Here, the court is forcing the jury, a nay person who's holding out, and telling them your duty is to find it guilty or not guilty. So after the jury reports its failure to reach a verdict, it's telling them they have to reach a verdict. And it's instructing them, so I would say this would put more pressure on that nay juror to reach a decision, and allows the other jurors to put pressure on that nay juror. Look, what is our duty? What is our one role here? It's to find the defendant guilty or not guilty. It's also misleading. They're never told that they are free to not reach a verdict. They're never told that. They're never told, don't worry about it. They're told, don't worry about the sentence. And in my brief, I've given you the imagination of the nay juror, and I don't want to repeat that here, but I've basically given you a walkthrough of what this nay juror must have gone through after saying, I'm not convinced. The juror foreman saying, okay, we'll ask the judge what the question is, and the judge coming back and telling them you have to reach a verdict. It's even more direct than the Allen of a second trial will be a burden on both sides.
Were there convictions on all counts?
In this case, 9 of the 10.
Okay, so presumably if they were hung up on 2 counts, then when they came back, there was 1 acquittal. Correct.
But no 8, we find him guilty of 8, and we're not sure about the other 2. They all did what the judge said. They reached a verdict. We would argue that there is error here, even under constitutional harmless error or statutory. We would argue it's hard not to see prejudice when the jury did not remain deadlocked, and they did come back with the verdict. We argue that this did affect Mr. Lewis's substantial rights. That's really my argument in a nutshell. We have a lot of other issues, like I said, but those I think would take a lot of time to get through. If this court has any questions about those other issues.
Any questions? Thank you, counsel.
Thank you.
May it please the court, Presiding Chief Justice Lukert and counsel. The state would disagree with Ms. Pickering's description of the court's response to the jury questions. There were 2 jury questions regarding the deadlocked jury. The first question that came back from the jury was, can we find the defendant guilty on some counts and not reach a verdict on others? And I'm paraphrasing. Can we find the defendant guilty on all but 2 counts? Trial court did not tell us where the jury stood, but responded to that jury question, yes. When the jury came back with the next question on what would happen to the 2 remaining counts, indicating that there was 1 holdout juror on 2 counts. The court asked with both the state and Ms. Wacie Seaton, who was the defense counsel on the case, for our input. I responded, and again paraphrasing the deadlock jury instruction, but that it would be up to the county attorney whether to pursue those charges, and I laid out in a brief, so I'm being somewhat redundant, but it would be up to the county attorney to decide what to do with the charges. We could either retry them, or we could decide to dismiss them. It would be up to the county attorney, and I would agree with appellant's brief. I do think that would have been a correct answer. However, defense counsel responded, and her answer was, I think you should just tell them they shouldn't concern themselves with that issue. And the records never reflect whether it was instantaneous or whether the court considered it for a few minutes, but you do see the court's response where the court says, I'm going to tell them basically the sentencing portion of the instructions. Your duty is to consider whether the defendant is guilty or not guilty. That's the instruction that they were referred to. There was no objection by defense counsel. We believe that that instruction that the court referred them to, certainly more closely in principle, followed defense counsel's suggestion as opposed to the state's suggestion. There was no objection when the court said that he was going to refer them to the disposition instruction. There was no objection by defense counsel. We believe under Adams that at a minimum it is acquiescence to the response given to the jury by the court. We would also take the position that it's invited error. Defense counsel could have offered the court to give the instruction, the deadlock jury instruction. That was not done. There was.
Well, wouldn't invited error be really more akin if they suggested this instruction and now claim error with giving it? Isn't that more an invited error rather than requesting a different answer and now
Probably
complaining that they didn't object?
I couldn't disagree with that. In our position, we think the acquiescence is by far the strongest argument.
And the acquiescence in your mind is what's invited error?
Yes, we believe that is the strongest argument under Adams.
But there is a difference between disposition after guilty or not guilty and disposition after mistrial for hung jury. Wouldn't you agree?
Certainly.
Yeah.
Yes.
And what was given is don't be concerned about the disposition after you've performed your duty of either guilty or not guilty. So it really didn't answer the question of what happens when you have a mistrial for hung jury. I mean, it's close. It's close. Don't be concerned with stuff you're not supposed to be concerned with, but it's telling them don't be concerned about what happens after you find guilty or not guilty, not what happens after mistrial.
It didn't answer the jury's question, and I don't, not to keep harping on the same argument, but defense counsel's suggestion did not answer the jury's question either. Her suggestion, you don't concern yourself with that issue. Well, obviously they are concerned with that issue. There were several other issues raised in the brief.
Can I move you over to prosecutorial misconduct, because that's one that's bothering me? It seems like the comments about victim dignity and you're going to get this case to go forward was awfully pervasive, and since you were trial counsel, that was clearly a calculated thread throughout your closing argument. Would you not agree with that? I mean, you said it an awful lot for it to be just a spontaneous kind of statement is what I'm getting at.
I don't prepare closing arguments with themes, but this rape case with these victims and under the circumstances probably was one of the most psychologically brutal rapes that I've been associated with. I tried to tie my comments to the evidence in this case. The first victim that we put on was told after she undressed to sit down, stand up, sit down, stand up, before she was forced to perform sexual acts. Her children were threatened. Basically told she couldn't go to the police because the defendant knew where her kids went to school and where she worked, and that he'd been sent there and he followed her home from Junction City. In this case, the first VDD, the victim, wasn't forced to pay for being raped, but the demeaning nature of these several acts that the state laid out in this case, and I don't want to be crass, but telling victim AG, the Blake May victim, that you women all aren't shit, forcing one victim to kiss him, forcing another victim to make sounds like she liked it after she had been forced to go to an ATM at gunpoint, after she had been forced to take money out of an account that she didn't have. The comments are there. This is always awkward because I don't want to sit here and say I didn't do anything wrong. At the time, on reflection, when I saw Ms. Pickering's brief, my response, oh my God, what did I do in this case? And then you try to take yourself back to the evidence that was presented. I would argue that some things could have been said better. Maybe I should have just focused on the evidence in its entirety, because there certainly was enough examples of brutality, either physical or psychological, that I could have made my point just by going over the statements that the defendant made to each and every one of these victims. These were psychologically devastating crimes, and I was trying to convey a point without, frankly, walking a jury back through each and every detail, or the important details of these crimes. I believe there was overwhelming evidence in this case. I don't believe there was ill will, and I don't believe it was gross or flagrant.
Well, the ill will and the gross and flagrant kind of gets us to the notion of what have we said in the past and whether professionals can be professionals even when the facts are terrible. And I think the heinous nature of the crime doesn't lower the bar of professionalism, and so that's the concern, that we're sort of down to our standard of whether this is reversible prosecutorial misconduct, because you've conceded that you shouldn't have said several of the things that you said. I think even if you didn't concede it, we'd probably be there anyway, or at least I am. So now we're really down to whether this is reversible error given the nature of the evidence and the strength of the evidence of your case. So do you want to address that specifically so that we can get to that point?
Certainly. With regard to the rape and aggravated criminal sodomy of first victim, VD, we had her ability to identify the defendant, although he had a scarf that he tried to put over his face. When she first opened the door, she got a clear visual. His DNA was in her underwear. And I'm referring to counts 1 and 2. With regard to counts 3, 4, 5, and 7, we have the DNA from what's been described as a Jason mask, the victim's DNA that was on that mask. During the search warrants, we recovered the clothing items that were described by the victims. There were different facial masks that were worn. Those masks were identified by the various victims. We had the firearms. One was an airsoft pistol, one was an actual firearm that were recovered during a search warrant. In addition, we had 2 vehicles that were involved in this case. One was a Ford Focus, a blue Ford Focus. The other one was a white Dodge. Both had been described by various victims in the 2 counties. The white Dodge belonged to the defendant, but we also knew that he was driving the blue Ford Focus that belonged to his roommate, Jonathan Jenkins, because we found a speeding ticket in the vehicle that tied the defendant to driving his roommate's blue Ford Focus. And we didn't call him for trial, but at preliminary hearing, we knew that he established he wasn't driving that blue Ford. The defendant was. So we had vehicles, we had the mask, we had the clothes, the dark attire, pants, gloves, masks that were used, DNA, and without closing argument, I believe a jury would have reached the verdict that they reached in this case.
As I looked at the evidence, I was the victim ALT, which is your ag assault conviction, and then the acquittal on the ag kidnapping, I think
Correct.
it was. That evidence was a little less direct. You didn't have any DNA. You don't have an identification solidly from the victim. So what evidence on that particular conviction, the ag assault conviction, do you think could overcome the comments made during closing?
We had the firearm that she identified, and we had a black size 12 tennis shoe that was located in her vehicle. Her vehicle was the one that was driven, or we allege was driven by the defendant, Tony Lewis. But she identified the black mask with the eye holes that were handmade or cut out in front of the jury. And we knew that the defendant wore those size 12 shoes because we found them during a search warrant. And I know I'm out of
Go ahead.
time. With regard to the confession we've responded to in our brief, the admission, we don't believe that the defendant was in custody at the time that Detective Lewis gave him the 10-minute interview. We set out the Jones factors, and applying the factors that were established by this court or announced by this court in State v. Jones, we believe that it would show that that 10-minute interview was non-custodial and had not reached the accusatory stage. The identification, we believe, is good as well. And with regard to the sentencing issue, the state would acknowledge there are some issues with the aggravated habitual finding under Turner. But if there are no more questions, I know I'm out of time.
With regard to that custodial nature, the defendant was ordered to that particular place by a superior officer, correct? Am I recalling? He was told to come to a certain place by a military person that was of higher rank.
Chain of command, yes, I believe that's true. I don't.
And then when he got there, he was directed to where he was to go by the military individual, correct?
Correct. And I believe the transcript would show that Agent Anderson said any witness who goes into that building, victim, witness, whatever they may be, goes through the same process.
I'm just trying to, and where I'm coming to is our cases talk about the objective, reasonable person analysis with free to leave, and does that when we're talking about the reasonable person, are we talking about a reasonable military individual of lesser rank than the person that put him there versus a civilian? Do you understand where I'm getting at? Is if I were told by a captain to go someplace and sit, I would sit there until I was told I could leave when I was in the service. That's what I'm asking is how do we factor that in to our analysis? You understand what I'm trying to say?
I do.
It's all driven by a reasonable person feel free to leave.
And you're under the discipline of the Army that says you need to go there and talk with these.
You need to go in there and sit down.
Yeah. Well, state's responsibility under a totality of circumstances, that may be a factor, but when you look at the nature of the interview, you don't think by any means it could be described as an interrogation. I mean, the closest we got was you go to any bars. Otherwise, that interview was small talk, and it was only 10 minutes long. And he wasn't even confronted with the fact he was a suspect in rapes.
And the other physical factor is, as I recall, that you have to surrender your wallet and keys when you go through this process. Is that true with anyone who enters that?
That was my understanding from the testimony of Agent Anderson, was if anybody who goes through there would have to surrender those items.
Any other questions? Thank you, counsel.
With respect to the interrogation, I think it's quite clear that he was not free to leave. He was ordered there. When he fumbled his way and appeared to be lost, he was told by his superiors, "Come follow me, I'll take you to that place to be interrogated."
What did he reveal that would have changed the outcome?
That he went to the clubs that he went to the same nightclubs where the victims went to and were followed from. In my brief on page 29, Mr. Lewis told the detective he had been at the pool hall the same night that ZG was sexually assaulted, but he only stayed for 10 minutes. And then at trial, that same detective uses that statement against him and says that he found Mr. Lewis's story of only being at the nightclub 10 minutes implausible. So that builds the state's case that Mr. Lewis was at that nightclub, that pool hall. And it actually builds the state case of the fact of the jury's told, well, once we found out he went to these same places, that's when we brought in and had him Mirandized. He had to empty his pockets and hand over his personal belongings. Page 28 of my brief. He gave up his car keys, cell phone, and wallet. Later on, I think it was one of the officers said, Agent Anderson testified that if Mr. Lewis had been terminated, his interview with Detective Lewis, Mr. Lewis would not have been free to leave because the CID would have wanted to talk to him. And again, that's in my brief. So we have a custodial interrogation here, one that did affect the trial, and we believe that those statements, the first interview tainted the second one because no Miranda warning was given to an officer ordered to report there. With respect to just jumping back to, I'm going to go back in order, I guess 3, 2, 1, issue 2 on the prosecutorial misconduct. These are horrendous facts. And we're going to have them in all these cases. But when you have horrendous facts, we ask the jury just to be told those and not to be told about the dignity of women, not to be told how the victim's day was today, not to be told that their rights were violated, not to be told that Mr. Lewis felt entitled. That could be said in so many cases, and certainly should have not been said here. I believe opposing counsel was correct that we should have just let the evidence speak for itself.
And if the evidence speaks for itself, and I'm not one that, because a case is strong, that you get greater permission to commit misconduct or anything like that. But how do you overcome the forensic evidence in this case?
It is quite an uphill battle. DNA of the found on the victim's underwear, but I wanted to point out to ALT's testimony on the aggravated. Again, see, her testimony is still her testimony.
I mean, this is not a consent defense type of case. How do you overcome that evidence?
About the DNA, no,
Yeah.
It's hard to overcome that. However, the DNA evidence was for not all the victims.
Well, only ALT didn't have DNA.
Right.
And all you've got there is an ag assault.
Right. So you don't have DNA there. You don't have DNA found for ALT. I don't
You do have
think
a
so.
size 12 shoe.
Yes. But when you have a jury instruction, and I'm going to go to cumulative error. And when you have a jury instruction that is response to a jury where they're deadlocked and told you have to reach a verdict, then you have a jury being told it needs to defend the rights of women and how they were violated. Then you have an interrogation that we believe was custodial. We believe this all adds up to cumulative error. We ask this court to reverse and remand for a new trial. If not, in the alternative, to vacate his 5 life sentences.
Other questions? All right, thank you, counsel.
Thank you.
Court will take this case under advisement. We'll call the final case on the morning docket, 106150, State versus Sharkey.
Michelle Davis on behalf of the appellant, Mr. Sharkey, and could I please reserve 3 minutes for rebuttal?
3 minutes, thank you.
Justice Lukert, thank you. It appears, there's 3 issues in the brief. It appears issues 2 and 3 have been addressed in one way or another. So I'll focus on issue 1, which was Mr. Sharkey, shortly after the verdict, filed a motion seeking a new trial, a pro se motion seeking a new trial, asserting that his counsel had been ineffective at trial and requesting the appointment of new counsel. And our issue is that he did not receive conflict-free representation on that motion for new trial, and that the district court erred in proceeding to summarily deny that motion without appointing him conflict-free counsel. And it's interesting, I think the one thing I want to clearly establish is that this was still a challenge to the conviction. This is not, I don't think we're subject to the case law here, as you would with a 1507.
I'm sorry, I missed just the last couple of phrases.
I don't think we're subject here to the case law that applies with a 1507 post-conviction case law because he's still challenging the conviction here. The conviction's still in play. And so on that basis, in our brief, he's entitled to the representation of counsel. He's entitled to the representation of conflict-free counsel. And instead, the district court never really addressed that issue.
Help me with that.
Uh-huh.
The distinction is that he still has the constitutional right to effective counsel rather than the statutory right to effective counsel, which we've said applies in the 1507. Is that what you're saying?
Well, the state, in our brief, I basically cite the cases that talk about, when then there's a hearing, that you have the right to have, it's a Supreme Court case that talks about Taylor. If a hearing is held and the state's represented, the defendant should be represented by conflict-free counsel, unless the defendant waives the right to counsel. And then, obviously, the Sixth Amendment's implicated with the idea of the conflict-free counsel. And then you've got the state statute that says you're entitled to assistance of counsel at every stage of the proceeding, and that this is still part of the trial proceedings because he's challenging his...
Bottom line, you're saying the post-trial motions are still a critical stage of the proceedings for Sixth Amendment purposes?
Because, yes, because he's still, yes. And so the cases that the state cite in its brief more go to a 1507 type proceeding, because the state's trying to sort of say, well, the judge didn't have to appoint him an attorney here. And the judge pretty much said to Mr. Sharkey, well, let me hear your motions first, and then I'll take up your counsel's, because his counsel had filed a typical motion for new trial also. And Mr. Sharkey said he didn't have anything to say. Apparently, Mr. Sharkey was confused because the court said, let's see if I can get this right, do you wish to address the court? And he said no. And he said, are you going to stand on your written motions? And Mr. Sharkey said no. So that's a little bit contradictory. And then the court summarily denied the motions without really addressing the merits of the motion. And so it's our contention that we can't really even address the merits of the motions because they weren't fleshed out, because there was no hearing. And what he's asserting in these motions is a type of thing that needs to get fleshed out, because he's basically saying it was my trial, my counsel sort of said it was a strategy not to testify. And I was hoodwinked, and then he makes some, so that basically comes down to conversations between client and attorney. And this was sort of this was a household situation. This was an Ag and Decent Liberties, but it was a friend of a child in the household, and Mr. Sharkey's alleging that there was conflict, and apparently there was testimony at trial that there wasn't conflict. He's saying he had conflict with his wife's daughter, and that was sort of his defense. And then he's saying that his attorney never investigated that and didn't talk to family members, and that those family members could have rebutted, could have provided that evidence to support his defense. So basically, he's alleging things in his motion.
I have a fact question related to that, though. Wasn't the conflict with the daughter a different daughter than the one who was a friend of this girl?
Justice Breyer, I'm not real clear on that because, again, I don't think we can challenge the merits here because I didn't challenge the merits in my brief because none of this got fleshed out.
Okay.
But I'm just trying to paraphrase what he alleged in his motions.
So there's nothing in the record that would answer that question. There's nothing in the record that tells us that there'd been any conflict really that would have involved that girl, the victim, somehow, right? There's just nothing there. And you're saying that's evidence of your problem. He should have had a hearing.
Right. I don't really have any details to go with because there was no hearing. And in the district court's position, one thing I also want to make clear is that the district court's position here was he told Mr. Sharkey, if you feel strongly about this, you can raise this issue of ineffective assistance of counsel in your direct appeal, or you can raise it pretty much in a 1507 in a post-conviction proceeding. But, here we are. This happened in 2006. This trial was in 2009. Here we are in 2013. Obviously, there is some benefit to a defendant of having this issue heard right after the trial, when everyone's memories are clear, when you can bring in these family members, when witnesses are available. So I think there's a question that this court needs to address. Is that correct to just be able to say, well, you can do this later, so as a trial judge, I don't have to hear this issue now, when there's clearly some benefit to the defendant to say of doing this now? of bringing his attorney in and when memories are clear, instead of trying to bring this up 7 or 8 years later when witnesses may not be available and memories are not as good. So I think there is clearly a disadvantage to a defendant from a trial judge just simply being able to say he's got a right to request a new trial. There's a statute that gives him that right. He's raising a basis to say, I did not receive a fair trial. My attorney was ineffective. I did not get to present my defense. He's got a right to assert that and to ask for a new trial on that basis. And for a judge to just simply say, well, you can raise this later, we believe is inappropriate.
If the judge had addressed it at that time and asked some questions of Mr. Sharkey, do you think, at least as I see the state suggesting, that would have been sufficient?
I'm sorry, Justice Luker, I'm not sure I understand your
Would
question.
you have an issue if the judge had asked some questions of Mr. Sharkey and Mr. Sharkey had responded? If there had been a dialogue about a fleshing out of the questions and answers at that point in time, would you still have an issue of ineffective assistance of counsel? Or do you think it would have been cured by questions and answers?
The problem with that is Mr. Sharkey does not appear to be the type of person who's comfortable holding that dialogue with the court. And so the advantage of having an attorney is somebody who can represent your position instead of you trying to do it yourself and then not speaking adequately and then saying, well, you didn't state enough on the merits.
So the only
proceed further.
remedy would have been to have continued the hearing, appointed conflict-free counsel, and then.
Yes, and I think I was confused by your question because I wasn't sure if you were asking would it have been appropriate for him to talk to Mr. Sharkey about whether there was a conflict or not, and whether he wanted to proceed or appoint new counsel. But I think that's kind of already addressed because the motion clearly shows there's a conflict, and Mr. Sharkey had filed a motion asking for a new attorney.
So those questions have already been answered in your mind, and the judge should have just proceeded to appoint new counsel at that point.
Right. Yes. Thank you.
If we would say this falls within a category of you're needing to show prejudice, how would you answer that? What prejudice would you say resulted by the judge's actions here?
Well, I think the prejudice is what I talked about earlier, that this is shortly after the trial, when memories are fresh, when witnesses are available. And so that would be the prejudice, that by having a hearing, certainly there's advantages to doing it both ways, but by having the hearing right after the trial, you're going to get a better, I think this defendant would have received a better. Of course, the only remedy that this court can do at this point is to send it back for a hearing on this motion. So for this particular defendant, but that is the prejudice.
It seems to me that your client, this is not an unusual course for your client, let's put it that way. I think there were 4 different times in which he's claimed each one of his trial counsel on 4 different occasions were ineffective. And now you're suggesting to us that he didn't know how to approach the court with that concern in this post-trial proceeding. And what's to prevent this? I mean, this is just going to be something that one might predict based on past behavior that's going to constantly occur every time he's appointed counsel.
He seemed to do fairly well with filing the written motion part. I think that speaking to the court part is where he didn't seem to do so well with. And in terms of constantly occur, I mean, this is one motion for a new trial. He's only going to get one shot at this.
I understand.
And I think that's my other concern in answering Justice Luker's prejudice is, the state saying, well, he can file a 1507. Technically, there's been a ruling on the merits here. I mean, you've got a judge that's denied his motions. It's possible that if he tries to file a 1507, the state can say, this has been heard. This has been ruled on. I don't know how that's going to play out.
I think we've said that when we've had a Van Cleve hearing, they raised some issues and then wanted to raise more in a 1507. We said you get one bite of the apple.
As long as you were same counsel, trial counsel. I'm a little confused by your response, and then
Okay.
kind of what I perceived to be a reference back to that response just now. Justice Luckert asked you if it would have been enough if the judge had merely questioned Mr. Sharkey and then by that question and answer procedure satisfied the judge that there was not a problem and then ruled. And I think you said the problem is that he was apparently not capable of handling the oral argument on his own.
Mm-hmm.
But is that really the only problem? Aren't you making a legal argument that any defendant in this position who alleges that he or she has received ineffective assistance of counsel by way of a motion for a new trial things have to stop
Yes.
until they have counsel?
Yes, I misspoke. I
Okay.
misspoke.
I was just confused. I just wanted
Yeah,
to
because you're right.
clarify that my
yeah.
earlier understanding of your argument was correct. Okay, thank you.
I kind of misspoke because I mean, ideally there would have been some dialogue here, but really, you're right. I mean, what's the point of having that dialogue when?
Unless he's
Yeah.
affirmatively asserted his right to represent himself,
Right.
then he has a right to counsel at that point
Right.
that hasn't been waived. And if he says, my counsel and I have a conflict, and the judge hears that and can't satisfy, if it's conflict based, I suppose the judge can satisfy himself or herself that there is no conflict.
Mm-hmm.
But if there's a question about whether a conflict exists, then your position is things have to stop,
Right.
new counsel has to be appointed.
Right. And I've seen that in other cases, and that's what's particularly troubling because other district court judges will just do that.
We've had this issue a couple times in recent appellate
Right.
cases.
And
too.
you'll see cases where they do that, and they'll just say, I'm going to appoint new counsel, I'm putting off sentencing, we'll take this up at a later date, and they do that. And then we have a hearing, and then we can bring up the IAC and the direct appeal because it's all part of the package.
As I understood your brief, your position is that by counsel standing mute beside Mr. Sharkey, Mr. Sharkey was totally deprived of counsel for purposes of that motion, and it was a temporary chronic situation.
Yes, that's
Complete
correct.
deprivation of counsel.
Yes, that's where I ultimately ended up with my shotgun approach, yes.
Okay. Any other questions? Thank you, Ms. Davis.
Thank you.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. I guess to some extent I'm somewhat confused. I thought that this court's case in Kingsley was this exact situation. And in Kingsley, the court indicated that with respect to both the statutory right to counsel and the constitutional right, that there's some latitude in there. And I think that latitude is what this district court judge attempted to discharge his duty. He was trying to inquire. He was doing exactly what, if not the only thing, short of automatically giving a defendant substitute counsel every time they say the word conflict, which is unworkable. This district court judge was attempting to do that very thing. He was absolutely stonewalled by the defendant, not once, but twice. There were some questions about whether this case would change if the district court judge would have taken the opportunity to inquire. That's exactly what he did, twice. He took that opportunity. Short of an automatic appointment of substitute counsel, every time someone files, says, mentions a conflict, I don't know how else the judge is supposed to resolve this situation. And with respect to the comments, with respect to the option of a 1507 thereafter, it was my understanding under Rice and Rowland that these, and also I believe at least Rowland, this court's case, was that in order for him to be more or less stopped from asserting a claim of ineffective assistance later in a 1507, these claims not only had to be ruled on, but they had to be addressed. That's the point. They weren't addressed here. there's nothing
But if it
stopping.
But if it was the defendant's fault that they weren't addressed, then he wouldn't be able to bring them again, would he?
I don't think this motion, as far as I know, the claims in this case, and any case like this, I can only speak for myself, and I guess and what I understand the law to be. There is no way that we would make a claim that he's had a prior 1507 or a prior claim of ineffective assistance, and there is no way any of the panels of the Court of Appeals that I've been before or this court would accept on this record that this man has had his claims of ineffective assistance of counsel litigated such that he could not bring them again. Plus, there would always be the exceptional circumstances. So whether you would find that he's never had the claim litigated or that under exceptional circumstances he could raise them again, I am totally confused on the concept that this man would not be able to assert these claims later in a 1507. But that's obviously not the issue here. I read in Kingsley that the district court is supposed to do this very thing that the district court did. I read in Kingsley that there is no automatic statutory right to counsel under this situation, and I read in Kingsley that this court indicates that there is a relaxation of the constitutional right to counsel as well until you can figure out what's going on.
The problem I'm having under the facts of this case are that I agree with Ms. Davis. This was on its face, Mr. Sharkey's answers were contradictory. And so at what point does a trial court stop and go, okay, it's obvious he's not understanding what's happening here, and at least ask, so does that mean you're withdrawing your motion? I mean, that seems to me to have been a logical next question after the second no.
And Your Honor, respectfully, that may have been a better response. But time and time again, I'm before some sort of court where they point out to me what the better response would have been, and respectfully, I think we need to address whether what was done here was error, and I think that shoots right into Justice Rosen's.
But the point of all of this is that Mr. Sharkey, at a minimum, needed to be told if you're going given some advice by someone, didn't he, to pursue this? When it was obvious to the court that he was not understanding it, don't the cases require more of the district court?
Well, I think that's where Justice Rosen's comments come in, and this is not someone who is. This is the first time I've alleged a conflict and so forth and so on. I mean, who's to say that? I believe it was the district court judge. Who's to say that they're not recalling that? I mean, we're looking at it in a vacuum, and you want some further indication that this person has been advised of some nature. Who's to say that he wasn't within those earlier 4 attempts? At some point, the district court judge needs to proceed on to sentencing, and when he's tried twice, I don't think that these comments conflict each other at all. What they show is a conscious effort on the part of the defendant to not litigate this or pull forward with it. I think that what I've seen in the past, and I'm sorry to go outside of the record, but what I've seen in the past is these exact same motions filed. You show up, and they will withdraw them. The motions are withdrawn upon the inquiry. And I think that's what this district court judge was doing, is the best that he could do at that time to figure out in these circumstances, what are we doing with these pro se motions?
See, I guess the problem I'm having is it seems like on this record we're having to read a lot into the record, one way or the other. It just doesn't appear that there was an adequate record for us to know what the situation was here. We're guessing. So what do we do with that?
Well, I think obviously, I understand I can't change that now. The record is what it is, and what happened, didn't. But I think that this court can be somewhat comfortable with the result here in that, as the district court judge indicated, this is not the end of this case for Mr. Sharkey. He has the ability to raise each and every one of these claims plus more in a 1507. So it's not as though these issues are not. It's not as though he's been stopped from litigating these issues, and he may in fact be better off in that now not that he couldn't raise ineffective assistance of appellate counsel later, but would have that ability now and bringing it all at one time.
I'm looking at your brief, and it's got a little bit of the transcript, and the court responded after defendant said, after the court inquired, are you going to stand on your written motion? The defendant said no, and then the court goes on to say that the record should reflect the defendant shaking his head in the negative, and after reviewing the motions, the defendant chose not to testify and has alleged various reasons in his motion that he felt like he was hoodwinked or whatever, but the court recognizes there were some serious downsides to the defendant testifying and being cross-examined, and he has a Fifth Amendment right to remain silent, not to incriminate himself, and he chose to exercise that right. The jury was told that with the court's instruction and heard that in connection with the verdict. So the motion for new trial and motion for reappointment of counsel will be denied. And so I'm trying to understand why that wouldn't be a ruling on the merits of the ineffective assistance of counsel that was raised in those motions that the court identified was being presented.
And then for the same reason that I indicate Rice and Rowland, I always get the two confused. I think that one might be the extension of the other. I think that there is no way that you can say that this was this man's opportunity to present this. If anything, as I believe it was in Rowland, anybody that's going to look at this is going to indicate that this person was not able to flesh out these claims. And I will always maintain, as well as I believe what the district court's unspoken word was, is these claims were conclusory. These claims were outright conclusory. If he wanted to litigate these now, the simple answer would have been, well, your allegations are conclusory and we're done. He always tells us that there's, oh, well, I've got all this wonderful people that are going to say stuff. That's basically what this is. There's no substantial question here to have a hearing on. I'm now convicted. I'm going to prison for at least 25 years. And something went wrong. It's his fault. There's people that would say things that would change stuff. It's just impossible. There's not grades of impossible. It's impossible to have a hearing on something like that. And I think that what occurs on our Justice Johnson read on page 5 of our brief, I think that's more or less the district court's way of concluding the pro se motions. I don't think that even the district court would indicate that this was an absolute ruling on the merits of these claims and he'll never be able to raise them again. I think this is just his way of moving forward. As he indicates at the beginning, first we'll take up your pro se motions, see where we go from there, and then maybe we'll get to counsel's motions. I think that's just his way of concluding in an orderly manner so that we don't have a claim later that the pro se motions were never ruled on.
And he does conclude that later by saying that there would be first and foremost the remedy of a direct appeal, which you'll be entitled to given the life sentence to the Kansas Supreme Court. But in fact, if he had raised that on direct, at most he could hope for Van Cleve, and it would have gone back for a hearing with new counsel.
Well, to have it addressed on direct appeal, yes, but that's still the other part of the statement is that he could raise if he feels strongly about the ineffective claims, he could raise them in the 1507. I believe that's in there as well.
Yeah.
So I would ask this court to do nothing more than to apply its precedent as indicated in Kingsley and find that the district court judge did under the circumstances what he could do with respect to any harm to the defendant. There is none. I don't think that there's a chance that he was barred from raising anything that he could have raised before. And in fact, I think he can improve his situation, maybe as Justice Johnson has indicated. Why didn't I get a Van Cleve hearing on appeal? Unless the court has any questions, we'd respectfully request that the district court's decision be affirmed. Thank you.
I would waive rebuttal.
Any questions for counsel? Okay, thank you. Court will take this matter under advisement. The court is now in recess.
All rise.